Hi everyone, my name is Jeremy Klein, and today I want to discuss the recent Supreme Court decision regarding arbitration clauses in employment agreements. Now, this decision can have a huge impact on the enforcement of employment laws, and many commentators are criticizing the decision for unfairly favoring employers and restricting employees' abilities to band together to fight potential employment law injustices. Now, the court was asked to decide whether to enforce arbitration clauses in several employment agreements that specifically required the employees to waive their right to participate in class actions. In a 5-4 ruling, the court ultimately determined that these clauses are enforceable. Now, the majority reached their decision by applying the Federal Arbitration Act's liberal policy towards favoring arbitration clauses, as well as the Act's basic rule that the courts must enforce arbitration agreements as they are written unless basic contract offenses for the revocation of any contract apply. Now, typically, in order to invalidate an arbitration clause and pursue your disputes in court, you would have to prove that your contract was either procured by fraud, duress, or is otherwise unconscionable. But the employees in this case did not take that approach. Instead, the employees argued that the contracts are illegal because they conflict with the National Labor Relations Act's law that requires employees to be permitted to take concerted activities in order to seek mutual aid and protection. Now, the majority was not convinced by this argument and ultimately upheld the arbitration clauses as they're written. Although the court appears to be applying the Federal Arbitration Act consistently, it may be time for Congress to rethink its legislation. The Federal Arbitration Act was initially enacted by Congress because they considered arbitration to be a speedy, simple, and cost-effective alternative to court litigation. However, the reality is arbitration is far from simple. It entails very complex rules and procedures and can often be much more expensive than litigation. So what does this mean for you? If you're an employee, this means read your employment agreement before you sign it. Now, I know in most situations you're going to be handed a take it or leave it agreement and not be given much negotiating power, but don't assume that you can't negotiate. It doesn't hurt to ask. If you're an employer, this may be a good time to revisit your employment contracts and decide whether it's appropriate for you to add to or alter your dispute resolution clauses. Of course, it's not always a good idea for employers to have arbitration provisions in their employment contracts because this can have implications for enforcing your non-compete agreements, your non-solicitation agreements, or even your confidentiality agreements. Hey guys, thank you for watching this video. If you learned something or you like the things we're talking about, go ahead and subscribe to our channel or click the link in the description, which will take you to our law firm's blog where you can learn all about this type of stuff. Thanks for watching.